In the structured realms of legal agreements, where promises are made and obligations are formalized, there exists the foundational and intricate field known as contract law. Envision a legal framework designed to govern the creation, interpretation, and enforcement of agreements between parties, providing a structured foundation for commerce, relationships, and the myriad transactions that define human interactions. At the heart of contract law lies the concept of a contract, an agreement between two or more parties that creates legal obligations. These agreements can take various forms, from written documents to verbal understandings, but for a contract to be legally enforceable, certain elements must be present. These elements typically include an offer, acceptance, consideration, something of value exchanged, legal capacity of the parties, and a legal purpose. In the mystical dance of contract law, the process begins with an offer, an expression of willingness to enter into an agreement on specific terms. The party receiving the offer then has the opportunity to accept or reject it. Once there is a mutual agreement, the parties are bound by the terms they have agreed upon, forming a contractual relationship. Legal doctrines such as the meeting of the minds become integral to the realm of contract law. This doctrine, also known as mutual assent, emphasizes that for a contract to be valid, both parties must have a clear understanding of and agree to the essential terms. This ensures that contracts are entered into voluntarily and with a shared understanding of the obligations involved. In the realm of contract law, contracts are classified into various types, such as bilateral contracts, where both parties make promises, unilateral contracts, where one party makes a promise in exchange for a specific act, and express contracts, with the terms explicitly stated, or implied contracts, where terms are inferred from the parties' conduct. Contracts can also be categorized based on their enforceability, such as valid contracts, meeting all legal requirements, void contracts, lacking legal validity from the beginning, and voidable contracts, potentially valid but subject to rescission by one party due to factors like fraud or duress. Enforcement mechanisms, such as damages or specific performance, come into play when one party fails to fulfill their contractual obligations. Damages may be monetary compensation to the injured party, while specific performance requires the breaching party to fulfill their contractual promises. In the age of complex business transactions and digital interactions, contract law adapts to address new challenges. Electronic contracts, online agreements, and smart contracts, self-executing contracts with terms written into code, emerge as innovations within the traditional framework of contract law. Contract law, in its essence, is a guardian of promises, a legal structure that provides certainty, stability, and recourse in the realm of human agreements. It reflects the societal understanding that individuals and entities should be held accountable for the promises they make, fostering trust and facilitating the myriad transactions that underpin modern life. As commerce and relationships evolve, contract law remains a cornerstone, providing a reliable framework for parties to enter into agreements with confidence in the rule of law.